On the screen with me is a document with the title New California Bill AB-1757 is dangerous for digital world. This bill could wreak havoc, and there are multiple reasons why. And today I'm going to explain some of those reasons, but I know a lot of people don't finish watching until to the end of the video. The big takeaway is this impacts everyone. It impacts consumers and designers, developers, platform providers, website owners, and on and on. So I'm going to go over the bullet points on this document to give you the quick takeaways from this bill. So owners of websites, mobile apps, and other digital assets can be sued. Every entity that contributes to that digital asset could potentially be sued. So I have sub bullets: developers, designers, provider platforms, email service providers. This affects entities everywhere. So any digital asset that can be accessed from the state of California could potentially be implicated. So this is a California state bill that could potentially become a California state law, but it doesn't mean it won't apply to other states and potentially even providers or entities in other countries. And it effectively mandates strict conformance with the Web Content Accessibility Guidelines, conformance level AA, version 2.1. And so what's in the bill is that there needs to be effective communication, but the bill also provides that that can be met by WCAG 2.1 AA conformance. So the result of this will be that plaintiffs' law firms will be looking for any deviation from full WCAG 2.1 AA conformance. So that's important to note, because while WCAG 2.1 AA conformance is possible, it is also very easy to be non-conformant, and there can be some minor issues that mean that you are not technically conformant with these guidelines. And it's also important to keep in mind that there are 50 considerations, 50 requirements under these technical standards that would now be effectively incorporated into the law. So that in and of itself will give rise to so much litigation. The bill would go into effect immediately, so there is no transition period. Seyfarth Shaw pointed this out in their blog post on AB 1757, and I will link to that below. But it's important to keep in mind that there's no waiting period. There's no time where that you're given 6 months to get into conformance. No, this would potentially go into effect right away. There's nothing in the bill that states that entities have 1 year to become conformant. Also, this will result in many digital assets being taken offline, because the cost of WCAG conformance is prohibitive for many businesses. So many small businesses, many startups, many entrepreneurs, the cost of making a website or a mobile app or another digital asset fully WCAG conformant is significant. I mean, $5,000 would be a great starting low cost for anything that was beyond a simple website. So keep in mind that the cost of conformance is very expensive. Now, one thing to point out, I know WCAG is for web assets, but as this bill, as I think this bill is applied, WCAG will be applied beyond web-based technology. And so I think the idea there is that the principles in WCAG are brought forward to other digital assets, such as native mobile apps, but that's actually not addressed in the bill. But it's glossed over. I don't know. There's not much else to say about it, but perhaps the people that wrote the bill did not know that. So there's beyond the cost of WCAG conformance, which is expensive, and in a more realistic world, probably $10,000 for a website to audit and remediate would be on the low side. And so you'd have to go to different providers and seek out quotes, but you're looking at 5 figures easily, is my point. I mean, realistically, it's very easy for, if you go to some of the more expensive providers, for audit and remediation to cost into $20,000 to $30,000 range. But I think that cost will come down, but the point is it's still expensive no matter what. It's several thousands of dollars. Also, beyond the cost, there's a timeline. So you can't just I can't just make a website WCAG. I can't just remediate a website to be WCAG 2.1 AA conformant at within a week. It's usually going to take longer because the website needs to be audited first. So you need to find all the issues which would be non-conformant, and then you have to remediate those. So if you are extremely fast, you might be able to audit and remediate within a span of 3 weeks. That'd be extremely fast. But usually that process is going to play out over months. So maybe 3 months on a quicker timeline, and then several months on a more realistic timeline. But in my experience, I have seen instances where even just a single website for, let's say, a larger company is going to take at least 6 months to be WCAG conformant. It's not that it has to take that long, but it just plays out to be that long. So this is not something that can be quickly and easily done by most entities. And so with the cost and the time considerations, it just makes it makes so many different entities open for litigation. So I think commerce will be ravaged because plaintiffs' lawyers will be acting upon this law if it were to be passed. Plaintiffs' lawyers would be acting upon it immediately because for them it's like printing money. It's very, very easy to make money in digital accessibility, especially with this new bill, which would really effectively greenlight any digital asset that wasn't WCAG 2.1 AA conformant. It would greenlight that, and that's with commerce being ravaged, you'd have small businesses being eliminated. You'd have medium and large organizations in a constant litigation battle, and then you'd also have what I was just about to get to is plaintiffs' lawyers will initiate litigation to argue technicality. So they don't mind. This is an asymmetric situation where plaintiffs' lawyers don't have a lot of downside, especially with this bill in effect. If this bill were to come into effect, plaintiffs' lawyers really they can only lose their time and the filing fee, whereas because they have the infrastructure set up to initiate litigation for as long as it takes, and just at continual litigation every day, demand letters and complaints filed in court. Whereas anybody else who would be defending against litigation, this is something that is entirely out of scope for them. This is out of their normal operations, something where they have to stop, they have to consult with counsel, they have to consult with an attorney, potentially hire that attorney, defend against litigation, possibly into a settlement, and there will be so many organizations that are unaware that this bill even goes. If it was to go into effect, they'd be unaware that it even exists, because even now, as what the primary litigation right now for the digital world is website accessibility litigation. There are still many people that are completely unaware that you can be sued for having a website with accessibility issues. So a few selections from the bill that I would like to read because I think they will expand upon what I've just said. And 2, internet website includes all internet web-based technology, including but not limited to a mobile application or app that can be accessed by a mobile device. So note that selection, all internet web-based technology. So this is not just websites. And of course, they're bringing in mobile apps, and presumably that includes native mobile apps and hybrid apps beyond web apps. But this is the language from the bill. I didn't write it, but this has broad and far-reaching consequences because it is going to apply to all internet web-based technology. The next selection, A, it is unlawful for any resource service provider in exchange for money to intentionally or knowingly construct, license, distribute, or maintain for online use an internet website that fails to comply with the internet website related accessibility standards. So again, this is saying you must be conformant with the web content accessibility guidelines. One note here, I don't know why everybody continues to get this wrong, but it's not comply. You don't comply with WCAG. WCAG is a voluntary technical standard. It is not the law. It may be incorporated into the law, but the law is what you seek to be in compliance with. The technical standards are conformance. So anyways, continuing on, that means that any resource provider that fails to maintain, construct, what is it? Maintain, license, distribute, or any license, distribute, or maintain for online use any internet website that isn't WCAG 2.1 AA conformant. That means that this would give potential rise to a claim. And again, remember that internet website doesn't mean just website; it means all internet web-based technology. And then the last selection I have here is service provider means that a person or entity that in exchange for money constructs, licenses, distributes, or maintains for online use any internet website or resource to be used within or in conjunction with an internet website. So not only can website owners be sued and mobile app owners, but also anyone who is involved really with the maintenance, construction, distribution, etc., of that website or other digital asset. So the language in this bill is very broad and it's not narrow. So broad is going to tremendously favor plaintiffs' law firms, which makes this extremely dangerous because plaintiffs' law firms will be engaged in continual litigation and it will not stop. So this is AB 1757 is extremely dangerous. The language in this bill, this bill does not it's not nuanced enough, it's not detailed enough to be ready for showtime because as it stands, what will happen is there will be continual litigation, and it will not stop. And it will be something that disrupts everyone, and ultimately, everyone will pay for it because the prices of everything will go up. So, dangerous bill. I will put more information below, including links to other videos and other resources. With if you would like to react, I will include more in the description below.